In today's lecture, we're going to be covering Chapter 11 of the text concerning the disclosure and suppression of evidence during trial. The discovery process takes place typically after the case is going to be set for trial. Basically, it's an exchange of information. Typically, it's the prosecutor giving their information to the defense. There are some states that require reciprocal discovery, so the defense has to give information that they learn to the prosecution as well. It depends on the case what information is actually required to be turned over, and also when it's required to be turned over. It's often described as trial by ambush in some jurisdictions, where they're only required to give this information either the day of the trial or even just a few days before trial, instead of having months to review the files that the prosecution has collected. The main thing is that they have turned over what's known as exculpatory evidence. That's any evidence that would be beneficial to the defense proving the innocence of their client, or information that points to another suspect, anything of that nature. And that's really what's tied up in the Brady rule as to what types of information have to be turned over. Again, anything that would basically help out the defense attorney's case, or that would show some other realistic explanation for what happened. Additionally, they have turned over what's known as impeachable evidence for the witnesses. If the prosecution conducted formal interviews with a witness and they gave conflicting information based on what they're going to testify to at trial, or if they've given conflicting information in official reports in the past, that information has to be turned over to the defense. Again, it depends on what jurisdiction they're in, whether or not the defense has to turn over, and what information they have to turn over as well. One thing that comes up, and it goes with the inner workings with the courtroom work group, is the idea of informal prosecutorial disclosure. It's at the whim of the prosecutor whether or not they want to engage in this practice. It's thought that by showing the defense partially what the case they're going to argue, that the defense is more likely to make a plea deal if they show that the case is very strong. But if the prosecutor and the defense attorney have a very antagonistic relationship, not a positive courtroom work group relationship, it's unlikely that they're going to offer any sort of information about what's going to be argued at trial. Again, that's one of the elements we talked about before, about prosecution and defense attorneys having to have this sort of working relationship to allow these things to sort of take place in the instance where they could benefit both parties by resolving a case in a more timely, more efficient manner. The suppression of evidence during this process, making motions to suppress evidence, is typically based on the exclusionary rule, which says that any evidence that was not collected in the proper manner must be excluded. Whether the police didn't get a correct search warrant, or they engaged in untoward practices during interrogation, there's a variety of reasons why something could be excluded. It also brings in the fruit of the poisonous tree doctrine, which basically says that anything that the police find from that initial illegal search or improper interrogation is what's known as fruit of the poisonous tree, and they wouldn't have found it otherwise. There are a few exceptions that have developed during the crime control Supreme Court era, so from the late 70s through really present, especially with the makeup of the current court. Some of the justices, there's two justices on the Supreme Court that shouldn't be there, but they are, and it's really changed the makeup of the court, and it's going to have lasting implications. But the three exceptions that we have here now to the fruit of the poisonous tree doctrine are, first, the good faith doctrine. Exclusionary rule is basically supposed to deter police misconduct. So if the police believe that they are in fact engaging in the proper manner with which they're supposed to collect evidence, they have acted in good faith, and a judge can rule that the evidence is still admissible. Additionally, if the information can be garnered from another independent source, independent of the wrongdoing of police, then the evidence can be admitted into evidence. And lastly, inevitable discovery. If some action that was already being taken would have um, produced the evidence, then it could be admissible. The inevitable discovery rule was really concreted by what's known as the Christian burial case. The police went to pick up a murder suspect in another city. He was put in a police car. The attorney told the police not to question him, that he was under the, he was the client of the attorney. On the way back, driving back to the other city, this was a case where a victim had been taken and killed, and the police engaged the defendant, not really engaged, but they were having a conversation about how it would be good if the victim could have a Christian burial. If they could find the body, they could do that, and sort of indirectly wore the defendant down in the back seat, and he eventually told them where the body was buried. They located the body, and a judge ruled that their sort of back and forth baiting the defendant into telling them where the body was illegal, but that searchers were already in the area. When you do a search like that, you quarantine the sections off and search in like a grid pattern. They were already eventually going to find the body, so the discovery would have been inevitable. It would have been discovered anyway. At the same time, the police were still engaging in poor actions and were reprimanded because of this, but the evidence was allowed to be brought into to trial, because it would have been discovered by other means anyway. We also talk about what sort of information the suspect gives up themselves. There's been an evolution of the voluntariness standard in the past. So before about the 1930s, police could just beat the shit out of a suspect, and it didn't matter what they did. If they got the confession, it was going to be allowed at court. So there have been some refinements of that, reducing the ability of the police to gain information through untoward tactics, torturous interrogations, overly long interrogations. In addition, the Miranda warning comes into account when the police are engaging in any sort of questioning or interrogation of a known suspect that's under arrest. So they have to make the person aware that they have rights under the 16th, 14th Amendment, that if they would like an attorney, they can have one present, and if they request an attorney, it shuts down the interrogation completely. There can't be any further questions that are asked without the presence of the attorney there, and any attorney that's worth a damn is not going to allow their client to talk to the police really for any reason. There's no benefit gained from talking to the police if you are a defendant under arrest. So, number one, don't commit crimes. Okay? Number one is don't commit crimes. That's the first thing. So, don't commit crimes. Number two, if you do commit crimes, don't get caught. Again, I'm not endorsing committing crimes, because number one is don't commit crimes. Number one is don't commit crimes. Number two is don't get caught. If you ignore those first two things and you commit crimes and you get caught, number three is shut up. You are, as a defendant, as the accused, you are never going to benefit yourself by talking to the police. It's not some TV show where the super smart criminal can outwit the cops. Don't commit crimes. Don't get caught. But if you do, shut up. Do not ever talk to the police if you are suspected of committing a crime. Request an attorney or call your own personal attorney, and they are the ones that talk to the police. As a criminal defendant, as an accused individual, you should never talk to the police. I'm not saying this in efforts to make police's job harder, but for your own protection as a citizen, do not talk to the police if you are accused of a crime. Number one is don't commit crimes. So don't commit crimes. But if you're in that situation, shut up. Just shut up. Next is search and seizure, and the way that is taking place. Typically, the police will bring the probable cause that they have before a magistrate judge, and they will sign a search warrant. The search warrant is required to include very specific details of who is going to be seized, or what, where, when is going to be searched, and what types of property are going to be taken. So the requirement of particularities. Then the police can only search exactly what's listed in the search warrant. If they screw up and put the wrong address down, they can't just do a whoopsie and search the house anyway. They have to go and get another search warrant. It does be very, very specific. Additionally, when they do a search warrant, they have to keep a list and inventory of the things that they take. They have to maintain the custody of those things, and they have to give the person that they took them from a list of the things that have been taken in inventory, and also a copy of the search warrant. Make sure it's very formal, that everybody knows what's happening, and that there's a record of what has been taken, so that when the trial process or the investigation process is over, they will be able to get it back. There's a very good example of this in the film Richard Jewell that came out last year, where they execute a search warrant at a house and they take all manner of things, and then they give them the big list at the end of the things that they've taken. Then later on, they give it back to them, and then it's left to these put upon people to scrub off the permanent marker stains that are put on things like Tupperware and all the other things that have been taken. But it's very, very formal process, and a very concrete record is kept of what's taken. There are a couple exceptions to warrants. The main thing is if the police observe a felony happening, or something's in progress, then you don't have to get a warrant. Maintaining safety, things like that. Although if, for instance, they see someone commit a felony, run into a house, and the police then enter that house legally, again, they've observed what's happened, then they find the person in the living room, they can seize the person, arrest the person, they can do a sweep of the house to make sure that no one else is there, there's not anybody hiding in the closet with a gun, but they can't search the house. They would have to wait and get a search warrant to actually search the house. Another exception is if the excuse me, if the if there's contraband in plain view, then again we wouldn't need a warrant. Again, if that same scenario happened, the police come into the house having observed a felony, and then there's a 2-pound bag of weed on the table, that's in plain view. They can seize that contraband without having to get a warrant. Although then they probably would get a warrant and search the rest of the house to try to find where the rest of the weed at. Additionally, the same thing can happen in a car on the side of the road. If someone's got a big lit hooter sitting in the ashtray when they get pulled over and there's smoke coming out and it smells like a Bob Marley concert, those things are in plain view. So again, I guess don't have contraband. Don't interact with the police if you have contraband. Don't have contraband, but then don't leave it out. I guess it doesn't work the same quite as the other one, but I think it should go without saying that if you're going to commit illegal activity, you would try to have as much evidence of that not out in the open as possible. But if you've ever seen the show Cops, you'll know that criminals are stupid and do stupid things all the time. Another area of searches that has developed more recently and more quickly over the last about 20 years is the idea of electronic surveillance, eavesdropping on or constant surveillance. Typically, you're going to have you have to show a court that you've tried other means of surveillance before they're going to allow constant electronic audio or video surveillance. It really just depends on the case and what the particulars are, but there's going to be very stringent restrictions on who can view that evidence, how it's stored. Also, it depends on what state you're in, whether or not you're going to be able to do video surveillance or just audio surveillance. Also, GPS tracking is coming under scrutiny with this, and those are all things that have to have a warrant. Even the idea of police using thermal cameras. The police can't just drive up and down a neighborhood with thermal cameras looking for marijuana grow houses, for instance. There was, however, a case a couple years ago. I think it was in Georgia. We had a snowstorm, and in Georgia that means about 2 inches of snow, and every house in this neighborhood was covered in the snow that had fallen, except for one house that there wasn't any snow, and it looked really weird. And they hit it with the thermal cameras, and it was a big marijuana grow house. That's how they found that. So it's kind of that plain view evidence that something doesn't just seem right here. But as advancements in technology develop, they have to sort of check themselves with the court as to whether or not they're going to be allowed to, or what standard that they have to reach to be able to be implemented in a particular case. And again, each case is very different. As far as the way the exclusionary rule applies in court and practically plays out, typically done as a pretrial motion initiated by the defense to exclude evidence that has been collected by the state against the client. The prosecution will then make a defense of the collection of the evidence, depending on what the situations are. The judge then makes a determination of whether or not the evidence has been collected in a proper manner, doing a Miranda test, a Brady test. There's been some research conducted with police interrogations. Overall, about 3/4 of the individuals that police interrogate waive the Miranda rights. Again, they didn't follow that, shut up mentality. Rule number three. Rule number three is shut up. That's the one you should follow. Again, don't commit crimes, but if you get to number three, shut up. Most of the people that they interrogate, though, do talk to them. A lot of it is wanting to sort of get it off their chest, or they feel like they're dead to rights anyway, or they're just stupid criminals and they don't understand the process, and that they could do number three and shut up. Some of them have claimed it as a relief of stress and relief of the conscience of the guilt associated with the crimes they committed. But because of the issues with the exclusionary rule and trying to maintain best practices, just about every police interrogation is going to be recorded. So if there are gaps in that recording, those are red flags for the court that something potentially improper took place. So if you have a situation where the defense has made a motion to exclude evidence based on the interrogation practices, and then the interrogation is incomplete, the judge is going to say, why is it incomplete? What happened here that the camera got turned off? And how does that relate to what the defense is trying to say? Again, another reason why police should be wearing cameras and have them on at all times, just so we have a complete record of what happened when some shit goes sideways. It's better to have that the camera as an unbiased observer. As far as the impact of the exclusionary rule at trial and how frequently it's invoked, pre-trial, depending on the jurisdiction, they see rates of 0.5% to up to 5% of cases involve some aspect of evidence trying to be excluded, and it typically is successful in maybe 1 to 2% of those cases where it's brought. So it's not very in modern times, because of the familiarity that the police have with the process. It's not very likely that they're going to engage in actions that are going to result in evidence being thrown out. Because when that happens, it's a big shitstorm in terms of the operational relationship between the police and the prosecution. They basically know better now. They know where the line is that the court has drawn, and they know how to not cross it. It also doesn't really show up in serious cases. There's not a rash of people being released on technicalities for homicides and things like that, as you would see in movies or television programs. It's just not the case. The police know better. They're trained better than they were 50 years ago, and they understand. The field of policing has evolved with these court cases, so that the officers know what not to do, and that makes the process have more integrity across the board. Again, because even if the outcome is not what the defendant likes, if the process is fair, then people's level of procedural justice is higher than it would be if they were getting a screw job. Okay, so be sure to review the court cases listed in the text. Familiarize yourself with those and how they apply with what we talked about here. And you can get a fuller picture of the evolution of the exclusionary rule, the Brady tests, even the development of the Miranda warning, to better understand it for yourself, to again maintain number 3 of shutting up. So, just again, I'm not trying to condone criminal activity, but from the standpoint of someone that has given informal legal advice in the past, again, I'm not an attorney. I cannot give legal advice, but I've given informal recommendations in the past, perhaps. The best thing that you could do if you are ever in a situation, or you know someone that's a defendant in a criminal case or accused being investigated, is to let an attorney speak for them, to speak for you, and to not talk to the police. So again, just review some of those court cases that are in the text, and we will move on with the trial process in future chapters.